All right, so also joining us tonight is a legal practitioner and also a rights activist, Bernard Edikon, who is joining us to help make sense of Nnamdi Kanu's trial and what is actually conviction rather at the moment and what it means for Nigeria. Thank you so much, Barrister, for joining us tonight on the program.
Thank you, Mr. Isong, for the privilege. It's a privilege to be here. Good evening, viewers.
All right, so Nnamdi Kanu's conviction, did you see this coming? And we've heard the defense team say they are going to appeal the judgment.
Well, it is the constitutional right of Nnamdi Kanu to appeal his judgment. Within 90 days, they have the powers to appeal. So I'm hoping that they will appeal it to the Court of Appeal and we'll see the outcome of the appeal.
Okay, but on the whole, I know you followed this trial. A lot of concerns from Nigerians. But look at the count. I think 6 count charges, bordering on different issues, and it all tied to the same issue that terrorism, treason, and all of that. As a lawyer, has it enriched our jurisprudence or some persons also argue that it's a sad day for the judiciary. What is your total overview of that particular case?
Well, my total overview of the case is that it's not an indictment on the judiciary to say. You see, in criminal proceedings, it actually starts with the police. The police arrest, they prosecute. It is the duty of the courts, the judiciary, to give judgment based on the evidence presented before the court. And overwhelmingly, if you look at the judgment of Honorable Justice Omotosho of the Federal High Court today, the judgment was self-explanatory and sound, in the sense that the evidence against Mr. Nnamdi Kanu were overwhelming. And I'm not saying that the evidence itself was too much, but when evidence is uncontroverted, like it happened in the case where Nnamdi Kanu refused to open his defense, the court has no option than to rely on everything exhibited by the prosecution, because the law is tried that where a defendant rests its case on that of the prosecution, the whatever comes in by prosecution, the court will look at it and give his judgment. I think that was what happened today. If Nnamdi Kanu had put in a defense to say, okay, even the video evidences, the whatever, for example, like you can say, I'm not the person in the background. I'm not the one in those voices. Okay, has anybody come out to say Nnamdi Kanu ordered me to kill anybody? Those would have been legal arguments that would have been canvassed. But he refused to enter his defense, and that is in a way that was what the law looked at. And I think the anybody that listens to today's judgment will see that the evidence against Mr. Nnamdi Kanu was overwhelming. And even if you tell you, Mr. Also, it would have been difficult for you to hold otherwise.
All right, so talking about the judgment, it was a long reading and explanation, done by His Lordship before it actually went on to all of that. But let's look at the trial. We saw the time when Nnamdi Kanu sacked very respected lawyers like Kanu Agabi, Ozekome, and even a lawyer, Jofo, at some point, and decided to take up his case by itself. For you as a legal practitioner, was it a wise move? Because maybe we'll see this pattern with some Nigerians who will now say, okay, Nnamdi Kanu took up his case, I can also take up my case. I don't need the services of a lawyer.
Well, that is another mistake, personally, I think that he made. You see, when people tell you they don't need a lawyer, the law is different from what we see. Some persons will even tell you, I think that's a mistake most Nigerians are doing currently. They said there are some things in GTP, I'm a professor in this, but the truth is, if you're not a lawyer, you're not a lawyer. For example, the argument he canvassed by saying that Section 36, sub 12 of the 1991 Constitution that says the law, you must be charged with a written law and this and that and the rest. If you are to be a lawyer, you would have known that whatever it is, whenever there is a general rule, there's an exception in law. In the judgment, my Lord make it clear that that same law provides that where a matter has been commenced under a repealed law. In fact, the Terrorism Prevention Act 2022, the current one, even made a provision in section 98 by saying that when you've been tried under this repealed law, it should be taken as if it is done under this one. If you are to be a lawyer, you would have done research to see that. He just took a section of the Constitution and was saying it as if he knows what he was in. But to be sincere, it wasn't a wise decision from him. A lawyer is a lawyer. A lawyer went to school for 6 years to learn to practice what is trade, and he knows what he's doing. So, and the courtroom is not, there are intricacies, it's complex. It's not just something you can just come up and say you can do it on yourself. I'm not saying anybody, it is your right to defend yourself, but it is wise to employ the services of a lawyer who knows the do's and the don'ts, technicalities, and whatever that might come with this kind of trial.
All right. So another thing that is mentioned now is outburst, and we've seen it repeatedly in in the courthouse, where he will have this exchange between himself and his lawyer, between himself and the lordship. And today's exchange, some person said maybe would have been ordered to be remanded for all of that, but it was just ordered to be worked out. How does this show our judiciary to the global audience, this exchange between those who are standing trials and questioning the judgments coming from that hallowed chamber?
Okay, well, it was a very unfortunate incident, and to be sincere, this is not the first time it has happened. I think from since when he elected to represent himself, at even the last adjourned day, there was an outburst between himself and the judge. He was telling the judge, "You don't know the law." I think the Honorable Justice Omotosho was even lenient and has been trying to comport himself in this trial till what happened today. In fact, in a way, it didn't put the judiciary in a bad light. It shows how
all right, Barrister, can you hear me?
To work him out.
Yeah, go ahead, speak to us.
Sir? Yes, and my lord was even writing in working him out of the court so that there will be a little decorum in the court. That is a temple of justice. You have to, the sanctity of the court must not be played with by anybody. He's standing trial, and whatever it is, I think the court did the right thing to restore decorum to the proceedings today in court.
All right, so if he decides to appeal the case, like his lawyers have talked about, will he have the opportunity at the appellate court to actually, open defense now, rightly, and put out his own defense?
Okay, well, that is it's a trite law. You cannot do that. The law is that you are not going to the appellate court to retry anything. You're only going, the opportunity for defense is gone, and it's gone forever. You are not going to the appellate court to reopen your defense again. You're only going there to say this judgment is wrong on this. My lord should look at this. They're only looking at the judgment of Honorable Justice Omotosho of the Federal High Court. They will not give him. That is not the law for him to open his defense in the appellate level. That is not the law.
All right. So some people have talked about the fact that this trial has delayed this long because they thought there would be some political solution to solve this quagmire, knowing how this could trigger reactions from the southeastern parts of the country. As a lawyer, and I know there is something called alternative dispute resolution. How do you look at this? Could these issues would have been resolved out of the courts, or can there still be a political management of the issue?
Okay, well, to be sincere, matters like these are political in the sense that it's a sensitive matter that can bring security breaches. If you look at today, the security operatives are saying that they sent a lot of security to the southeastern region to avoid the breakdown of law and order. So I think matters like these are political, and I'm hoping and praying that the president look at it, and maybe they can grant him a presidential pardon at the end of it, because political solution at the end of the day to me is the best solution to what has happened. Even if the way he went about it was wrong, it is clear that he was agitating for self-determination, which is a right in international law. It's a right. It is right to say we want to secede for self-determination is a right, as my lord rightly said in court today, is a right. But the way you go about it, so I think political solution will go a long way in bringing a lasting peace to the south eastern region. So I'm hoping that the president will look at it and maybe grant him a presidential pardon at the end of the day.
All right, so some persons were expecting it to be a death sentence. When my lord paused that judgment for 1 hour and he said he will come back by 3:40 and all of that. But we are now seeing life in prison. What have been the difference? My last question for you tonight. What is the difference between a life imprisonment and maybe just giving an outright death sentence?
Okay, well, the act prescribes death sentence. That was why the prosecution counsel was insisting that the law is the law. That the law has said if you are found wanting terrorism charges, it should be death sentence. But my lord looked at it again and was very lenient in that there is an international outcry against death sentence. Life is sacrosanct to God, and it shouldn't be taken just like that. So there are this international jurisprudence, criminal jurisprudence that believes that instead of sending someone to death, it should be by they should just go in for life imprisonment. I think that is even in the circumstance that is the line that my lord told. And also, before you even this thing, I think in a way that is the best thing to have. My lord has, in fact, my lord, some persons will say he did not stricto sensu hold on to the written provisions of the law in the sentencing, but I think it's a very lenient sentence when it comes to the worst. That would have been the best case scenario out of the worst scenario. So it's a good one.
Thank you so much, Barrister Bernard Edikong, a legal practitioner and human rights activist, for speaking to us tonight. We hope to have you in our studios one of these days.
Thank you very much. I appreciate it.
All right, and that's the size of our program for tonight. Remember, Nigeria is our country and we must contribute positively to the growth and progress of this country.